The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Four cases will be submitted this morning. Those cases are Joseph Walsh versus Teresa Wahlert in the state of Iowa. Second case is State of Iowa versus Carlos Ramon Mulatello. Third case is Matthew Yonka versus Deere & Company. And the final case is State of Iowa versus John Mulder. We'll now hear the arguments in the Welch matter. Ms. Flynn.
Thank you. May it please the court, counsel, my name is Megan Flynn. Along with my partner, Michael Carroll, we represent Joe Walsh. I'm here today on behalf of him in name, but also in substance, perhaps the public of Iowa. We are here today to protect public policy in a variety of forms. We have the 70A.28 whistleblower claim, and we also have a claim we believe operates in tandem with that claim, the wrongful termination claim in violation of public policy. I have three general topic areas that I'm prepared to address today. I can do it in any order that pleases the court. The first is the exhaustion requirement and whether Mr. Walsh was required to exhaust his administrative remedies via an action through the Public Employee Relations Board, PERB, or whether he can go directly to court for the whistleblower statutory action. The next area I'm prepared to address is whether the wrongful termination in violation of public policy claim is available for Mr. Walsh, a Merit System employee, and then more generally, employees other than at-will employees. I did also make some notes on what I saw happen in the Ackerman matter, which was some discussion of the exclusivity, potentially, of the remedy available under 70A.28, and I'm prepared to argue that that should not be an exclusive remedy for Mr. Walsh. Starting with the exhaustion argument, we should probably always start with the plain language of the statute and no deviation in this case. The statute provides that an employee may bring a civil action or may also bring an administrative action. May also refers to the administrative action available for employees other than merit protected and collective bargaining, but they also have administrative rights available. That, at first instance, would seem to indicate by itself that no exhaustion of any administrative remedy is required. However, if we look further, we determine from the case law, potentially Riley, as the state has argued, that use of may is not dispositive, so we need to consider the issue more carefully. We see that in Riley there's a two-part test for whether an administrative remedy must be exhausted. First, there must be an adequate available administrative remedy, and then we look to the statute to see whether it's express or implied that exhaustion is required.
What's inadequate about the remedy? And it seems to me the remedies, the administrative remedies are a little bit open-ended. I'm not sure I know exactly what remedies are available, looking at the statute, but it's not clear to me that you can't get attorney's fees, for example, and it's not clear to me that you can't get emotional distress damages. I double back to where I began. Why are the remedies inadequate? The administrative remedies inadequate?
Well, I've written down the remedies as, you know, that mirror one another between the statute and the administrative remedy, potentially reinstatement and back pay. And beyond that is where we get into the gray area. It
says other appropriate remedies, I think. I'm not sure I know what other appropriate remedies are.
And I'm not sure either, but it would be far afield to me to interpret that to mean attorney's fees and costs, at least as explicitly as set forth in the statute. But there's one big kicker, I think, as well, which is we can't forget that 70A.28 contains an express right to injunctive relief. And that available from a court seems to me to be quite different from something that you could get from a politically appointed PERB board. And so when we're talking about injunctive relief in the statute, we not only have that right expressly, but if you see the Worthington versus Kenkel case, we see that it's not exactly the balancing that we approach in just your standard injunction analysis, but it
Fair
may
enough.
be.
But is it possible to say that, well, for purposes of injunctive relief, it's not exclusive? Worthington is pretty good authority for that. But for purposes of other remedies, it is. I mean, can you have a hybrid approach to exhaustion?
So are you saying that someone might be able to go to the court for injunctive relief only, but not be? And I struggle with that because I think if you're looking realistically at who is going to get into court and to incentivize people to get into court to pursue that injunctive relief, I do think you want the express right to attorney's fees in tandem with that and costs. I know that it may be implied, but the likelihood is much more express if it's in the statute. And so if you're talking about realistically enforcing the right to injunctive relief in district court, I think that there is no adequate remedy under the administrative statutes. I think other appropriate remedies, I don't believe I have seen that particular language used to incorporate attorney's fees and injunctive relief. So that's what I have to say about that. On the wrongful termination of public policy claim, that's a much broader or narrower question depending on how you look at it. Here we have a merit-protected employee, but there are other classes of employee, collective bargaining employees, contract employees, at-will employees, and the question of do we permit only at-will employees to bring public policy claims? The public policy that...
We don't really need to get to that, right? The real issue here is the narrow one that you've just identified a moment ago, which is, do you allow somebody to bring a public policy common law claim who is a civil service employee who has expressed protections under an administrative scheme as well as under 70A.28, perhaps, we'll decide that, against wrongful termination, right? Isn't that all we have to decide? We don't need to decide the broader issue today, right?
Well, I think it's possible that you could, in our case, decide just the merit system employee. Do merit system employees have this right to a wrongful termination public policy claim?
States quoted the restatement of employment law, the comment that indicates that they don't. So, and what's your response to that?
My response is, if we look at Iowa law regarding when a statutory right is an exclusive remedy, and I hope I'm addressing the point that you're looking for here, but...
Oh, no, you're not. Sorry to interrupt, but there are two separate claims here. One is a statutory claim under 70A.28. The other is a common law claim, the public policy claim. So you have two separate claims.
Yes.
In the Van Bali case, for example, a common law claim of wrongful termination was held to be, not to lie, because there was a comprehensive administrative remedy available. Now, the argument is different with respect to the statute. But on your common law claim, different claim, why wouldn't Van Bali, if I'm pronouncing it right, be controlling on the common law claim?
Well, I don't think it is on the common law claim. I don't think that there is either a policy or a line of case law. So to take the two separate arguments. So the policy is that employees, whether they're merit protected, contract, collective bargaining, whatever they are entitled to be protected by the state of Iowa regardless of their status. And also, because of the precedent of this court, we can't ignore Conaway, we can't ignore Sanford, we can't ignore Harvey or any of the case law that's come before and has really can be read to create this wrongful termination in violation of public policy right for employees other than at-will employees. So there's that line of case law, there's the policy that supports it. And then when we're talking about the Van Volley case and comprehensive statutory schemes and whatnot, we don't have that here.
Well, I mean, Van Volley has good and bad for you. I think it's difficult for you on the common law claim because you have the merit system, administrative apparatus, versus a common law claim. You might say the legislature intended that the merit apparatus be exclusive impliedly.
But it's
On your
implied.
statutory claim, Van Volley does not control. In your statutory claim, you've got an express statutory provision saying there is a civil right, a civil action, and you have a comprehensive statute, 90 or 70A. It's a different ballgame. But you're on a stronger footing, it seems to me, where you have an express legislative statement that a civil cause of action exists. And now we have to compare that express legislative statement with what happened subsequently in Chapter 8A.
Correct, and I want to make sure that I'm talking about what you want, but the express right contained in 78.28, if I'm not mistaken, it doesn't say anywhere that it's exclusive, and it did post-date Springer. So we did have that wrongful public policy claim alive.
I understand that. I guess what I'm saying is a possible resolution, and I'm just hypothetical here, but a possible resolution is you don't prevail on your common law claim, but maybe you do on your statutory claim because there's different analysis.
Absolutely, that's a potential, and that's something we've given a great amount of thought to. One thing that came up when we were thinking about that, and by the way, I think if that is the result, I think it absolutely has to be that somebody gets to district court under 78.28 without exhaustion, or I don't think there is an adequate remedy that could replace the common law right and be considered comprehensive. or
Counsel, why do you need a common law right if you have a right to sue under 78.28?
Well, the common law right, it has punitive damages and emotional distress. Granted, in this case, it doesn't have the availability of punitive damages, but emotional distress is a large factor. And we're talking about whistleblowing. We're talking about violations of law, mismanagement, gross abuse of funds. We're talking about the types of things that we want people to have real access to. And to say that fee shifting in a statute gives them real access is ignoring the realism of the situation. Because
So then if we allow a common law claim, aren't we making an end run around the limitations the legislature chose to put in 70A? If they didn't allow punitive damages or emotional distress, they made that policy choice. Why should we allow you to step around that through a common law action?
I don't think we are for one reason, and that is because the elements of proof are different. And in particular, causation is a higher standard under the public policy claim. And so if you're going to obtain, it's a determinative factor, so if you're going to obtain those additional remedies, you're going to have to prove it. And I think there's another reason, which is that the legislature legislated with the knowledge of a potential public policy claim and specifically did not exclude it, because the language, again, is permissive and there's no mention of what happens to any potential public policy claim. And this is coming after Springer.
But the idea of this statutory public policy wrongful discharge claim is that you're carrying out a statutory policy or a constitutional policy. So here the statutory policy you're carrying out is expressed in a statute that gives at least an administrative remedy and perhaps a statutory remedy as well. So why would you create a common law claim? I mean, we don't just create claims to create claims. The theory behind the claim is that you're implementing a statutory policy. Here the legislature's implemented it for us, right?
They have. I don't know if analogy to the Zinsser case can be made. That's Iowa OSHA, because there was that same question of exclusivity or not. Granted, that was an administrative remedy in the OSHA scheme, but I do think that we are not creating this right. This right exists through Springer. I mean, granted, we are applying it in this situation, but we are giving tandem rights, and there's other situations where rights work in tandem together. And potentially what we are allowing is broader relief. And an analogy that may not be perfectly apt that I was thinking was negligence and negligence per se. We know from the statute what absolutely is a violation of the language of the statute. And there's different elements of proof involved in that. And then we know.
Can you pinpoint a little more clear where the policy is derived from?
Well, I do believe that the policy is derived from 78.28 subsection 2 and the protection of employees who blow the whistle on the types of violations of law and mismanagement, gross abuse of funds, whatnot. Is that answering your question, or?
Well, doesn't that statute provide for a remedy?
It does, and I struggled with that myself.
So where are we gonna provide, where does our ability to provide something in addition to that come from?
I think it comes from the case law, including Zinser and its progeny that talks about when, and may I have a moment to just finish this thought, when exclusivity it happens, and that's either when there's a comprehensive scheme created or when the legislature creates new rights and corresponding liability. And because Springer happened first, that didn't happen in this case. Thank you.
Thank you as well, Ms. Flynn. Mr. Thompson.
Thank you, Chief Justice. May it please the court, counsel, good morning. Let me just begin by trying to go back and address a couple of these questions, because I think a number of you have pointed out we have two pieces here. We have this common law issue and we have a statutory issue that I think can be resolved by statutory construction to a large degree. But on the common law claim, Justice Mansfield and Justice Appel, you're both correct. We think Van Bailey should control here, that the guidance there is right on point. Civil service, not exactly 8A, but pretty close. That the restatement of Employment Law 5.01, comment E in particular, specifically deals with this and catalogs cases.
Well, let's dive into the statute, if you don't mind. And the statute is interesting.
Okay.
Passed, as I understand it, and I look for guidance here because I may not have the history quite correct, but as I understand it, at least, it was passed in 1989. And at that time, of course, it had the civil remedy in the statute. Section 2 was there.
Correct.
As of 1989, when the statute was passed, my question is whether a merit employee in 1989 would have a civil cause of action under Section 2 of the statute.
Before 8A.
Yeah.
I think they did. And I've looked at it too, to be frank.
And I will say, I think so too, was about the same.
And there's no case
with the same caveats.
Right.
So we'll both reserve our right to
okay.
maneuver a little bit.
Right.
But assuming it is true that there was a civil cause of action.
Right.
What is it in the passage of 8A in 2003, I think? Maybe I have the date wrong. But what is it about the passage of 8A that suggests that there was a legislative intent to extinguish a pre-existing civil cause of action?
Well, I think just the plain words of the statute, frankly, because it makes a distinction. In other words, so we have a couple of things, Your Honor, and I think you back away, I think you're doing the right analysis, but we look, I mean, the canons of construction, I think, answer this question, frankly. We have a general versus a more specific statute. We have all state employees versus merit system employees only, which is also the later statute. So under the canons of construction, both the more specific and the later statute should control,
Well,
if there's a conflict.
If there's a conflict.
I don't think there's a conflict.
Well, I don't either. I think there's
Right.
parallel remedies, maybe.
I don't think so, not as to merit employees, because if you look at the way it's framed, and if you look at 8A and the definitions of what is a merit system employee, and then the laundry list of exclusions, right? So there are state employees, which is the bigger Venn diagram. There's a subset which are merit system employees, and what 8A does is it creates an exclusive remedy and put the same essential items into 8A 417 for merit system employees to follow the merit system, which is exclusive and requires exhaustion, but it also maintained this broader right for at-will public employees, which gave at-will employees, frankly, greater protection, which this court has already said is important. And then in a subsequent amendment, which I think is important, created for at-will employees who are public employees a permissive ability to go into the merit system, go to PERB. So it's mandatory for merit system employees. It's permissive for at-will employees. An at-will employee can file a cause of action, or it can permissively go into the 8A system. And so I think the later statute is intended to, as 8A and the legislative recitation says, is to dovetail the merit employee system and make it consistent throughout the state, and also make it coordinate with the contract employees' rights under their contract.
You haven't got me yet. You may, but there's no express provision in 8A telling us that there aren't parallel remedies. I mean, you know, the statute, when they passed the statute, they didn't declare that it was exclusive and basically preempted. Maybe that's a bad term, but so we're only dealing with implication, I think.
I don't think so, because if you look at the subsequent amendments to 70A28, that adds a specific provision that says a merit employee, it's limiting. It's not anybody covered by the statute, which is all public employees, that a non-merit employee can also go to PERB. And it gives that employee on a permissive basis the exact same remedy that the merit employees all have, which is exclusive under 8A. I just, you know, the 8A framework, it's undisputed that Mr. Walsh is a merit employee. And so that's a more specific designation than just generally being a public employee. And I think that both the timing of the statutes, the rule about specificity versus general would break the tie, but I don't think there's a conflict, because the canons tell you, you have to read them, that there's no conflict.
That's kind of a weird way to, isn't it, to, you know, if the word things in 2006, if they meant to say, if in 2006 the legislature's assumption was that the existing 78.28 only covered the non-merit employees, why did they then add the section that said a non-merit employee may also bring a civil action? It's just weird, it's strange wording.
Well, but it says may also go to PERB.
I mean, not a
In other
civil
words,
action, may also bring administrative action. I misspoke.
Yeah, it recognizes that the merit employees already have a different remedy. And so under 70A28, it's saying we're going to add that to the remedies that the at-will employees have.
I know that
It doesn't, it's a difficult statute, I can see.
I know that the legislature doesn't like us sometimes to look at this, but there is the summary of legislation that they put out for the public, and it's available, so I guess we look at it too. And in 2006, when they added this language, it says the right of an employee to enforce their rights under this section through a civil action is unaffected by the act. They didn't say the right of a non-merit employee to enforce their rights under this civil action is unaffected by the act. I mean, I think it does give the impression that the legislature understood in 2006 that the civil action remedy was available to everybody.
Well, and there's an implication there that's not clear in the statute, and I agree that, but we're faced with the words of the statute, and the words of the statute make a distinction between all public employees and merit and non-merit employees. And I think that the 8A and 8A 417 and 70A 28 kind of in the same universe and not conflict is to do this distinction, which is one is a broader statute that covers all state employees including all those people excluded from the merit system. And the merit system, 8A, is an exclusive remedy intended to be like a civil service system for people that fit that statutory definition. When you look at, in addition to the comments, you look at the statutory language of 8A, 411, 412, 413, it says all employees that fit this definition, except for the exclusion, shall be part of the merit system. And that dash shall provide a mechanism for dealing with discharges and demotions. I mean, it's all mandatory language. And this court has always viewed 8A as a mandatory program.
Except we have may twice in 70A, when we're talking about you may bring a civil action and you may have, and the Zinsser case deals with that
It
problem.
does, but if you go with my interpretation of these statutes, Your Honor, then that's not a problem. That I will concede to you that 70A28 as drafted is a permissive statute. It's got, you may file a civil action, but then it doesn't say everybody can also, it says non-merit employees may also go the 8A process. So that's why it's not exclusive and exhaustion required, and I think that's consistent with Zinsser. Zinsser does not answer the question that you and I are talking about right now, which is, does 8A require that, and is it mandatory? And I think one of the things that's unfortunate about this case is I think there's been a disconnect from the beginning. I mean, the district court did not find that Mr. Walsh didn't have a 70A claim because he failed to exhaust, found he couldn't bring one. Said that he didn't have a 70A action, and that's why you and I are having this discussion, and that he had to bring it under 8A 417 because of the plain language of 8A. He went on to talk about exhaustion, which I think, in part was a little confusing, but I think is relevant to the second question to some degree. But I think that this is, when you back away from it, a pretty straightforward statutory interpretation question. Doesn't mean it's not hard, but if you read the language, the only way to read those two statutes and give effect to those two statutes, which is what the law tells you to do, is to say that this is broader, this is narrower, and it works that way. If you're a merit employee like Mr. Walsh was, 8A 417 is your path. He didn't follow that path.
What about the adequacy of the remedy, if we can shift to kind of a different topic? It's unclear to me what remedies are available under 8A. Can you help me with that?
Well, it's real broad. You're right. It's nonspecific. I mean, the PERB rule is basically to make employees whole. So you get everything, including reinstatement with back pay.
Emotional distress damage?
I don't know. There's no case that says that.
Attorney's
There's no
fees?
case, of course, that says that not having emotional distress or punitive damages or attorney's fees makes an administrative remedy inadequate. I mean, you've over and over again said it doesn't mean you don't get what you want. It just means
That's right. But if emotional distress damages and attorney's fees were available, we wouldn't be having the discussion.
That's right. That's correct. But the other thing, and I think this is important, is if you read the statute the way I'm suggesting, what it does is 70A28 gives at-will state employees a slightly different set of remedies, slightly broader, arguably, because they are people who don't have the protection of the merit system. And that makes total sense. And the legislature could logically and reasonably think that that's why those at-will employees need a different path, and that 8A ought to govern this thing. I mean, there's,
The language says, when they added that, it says may all, I mean, what the legislature did was added an administrative path for
an at-will employee?
at-will employees.
Yeah, absolutely.
So everybody's on a par. You have parallel remedies. Both merit employees and non-merit employees, arguably, have parallel remedies.
I mean, recognizing a parallel remedy to 8A for a merit employee would be a really break. And this gets back to Van Ball, right?
Van Ball, I think that's distinguished. Van Ball or Bally, whatever, there was a common law claim. And I understand the argument that the legislature impliedly, through a comprehensive civil service statute, extinguished the common law claim. But that's not what we have here. I mean, what we have here, at least as plaintiff characterized it, I think, in part, as a battle between two statutes and what they mean. And it seems to me that's a,
Well, again, it's as to 70A versus 8A 417.
Yeah.
But as I think Justice Mansfield said, and somebody else, maybe you, that whether Mr. Walsh gets 8A or 70A 28, he's got a remedy for the exact public policy issue that they're arguing for a common law remedy. And I didn't get there, but I want to go back and say, because I think Justice Cady was at least asking about this, is that I think Van Bali should be a controlling case. I think the restatement correctly cites the way this court ought to go. But you reach the same result under your Harvey analysis, which is this two-step analysis where you first look to see whether there's a compelling need, and in this case, there's a just cause provision in 8A. There's no compelling need. Step 2, we look to the statutory policy, and in this case, whether you go 8A or 70A 28, it's set forth in a statute, but in the very statute where the state and the legislature declare the public policy that needs to be protected, the legislature creates a remedy. Now, we can talk about whether it's perfect or the same, but certainly under whether you're looking at Van Bali or the Harvey analysis, that there is no need for this court to extend this wrongful termination against public policy tort to state employees because they have 70A 28, or I think to any merit-covered employee, which is frankly the same analysis that the restatement in the Van Bali case does.
and can a merit employee bring an injunctive action under 70A?
I think Worthington is not clear about that. I don't think you can read, Worthington was a private employee, it dealt with a totally separate analysis. It dealt with just the injunction, and it was pre-8A, and it was a non-merit employee. It dealt with 8015, which is a statutory scheme the Court of Appeals has found to be exclusive and require exhaustion. So I think Worthington opens the door to your argument that maybe injunctive relief might be different under my analysis. I don't think it holds that, and I don't think that it would be inconsistent or inappropriate for the 70A 28 remedy to be different and perhaps robust than the 8A 417 remedy. I am out of time unless you have any further questions. Thank you.
Mr. Thompson, thank you. Rebuttal, Ms. Flynn?
I'd like to return to probably what is our tough sell argument, which I interpret to be, at least from the questions this morning, that when we have a statute that sets forth a public policy upon which a public policy claim would be based, why would the common law claim still need to exist, or how can it exist? I agree that may be a tough sell, but I think it's worthy of consideration on two different fronts. Number one, I would say that we are not creating a new common law right. We are acknowledging an existing one that the legislature was aware of when it created 70A.28. And I would encourage us to think as to whether the common law claim could be broader than the statutory claim, just because of the prior precedent of this court and the Court of Appeals when interpreting public policy claims, and to describe at least one of the challenges we face as litigants when we're under the 70A.28 rubric, which is strict construction of the statutory language, and whether the public policy of the state that protects whistleblowing could extend beyond strict construction of statutory language. And if you look at the briefing below, you'll see some of that in practical application. Are we talking about the right kinds of public officials to whom disclosures were made, et cetera? And maybe the answer to that is that the courts must keep in mind the public policy of the state when they interpret that language, and the intent of the legislature in enacting it. But maybe another answer is that there is this common law claim that's very real and existing, not that we're creating, and that should work and operate in tandem, and if not together, maybe at least as an alternative pleading. As to the exhaustion issue, I agree with the points regarding the legislative history and how this statute evolved, and I question whether we're reading portions of the statute out if we do not allow somebody to go to district court with a 70A.28 claim and instead we have them go through the 8A system, which my understanding is they never get to 70A.28. I'm confused by the argument that the district court kind of got that wrong, because if you're under Chapter 8A, you end up with a 17A review, and there's no statute directing you back to 70A.28, so I just don't see how an employee ever gets to a district court 70A.28 claim if you're a merit system employee.
You gotta do it through Chapter 8. I mean, I think the suggestion is that language, and I think it's 417, maybe I've got the number wrong, but I think it's Section 417, is largely paralleled, indeed almost verbatim, of the language of 70A, and has a mandatory feature to it, and therefore the legislature must have intended to basically extinguish a pre-existing civil action for merit employees.
Right. I think I understand that argument, but I vehemently disagree with it based on the existing language of the statute and what came first, and the may also language, and then this illogical separation of merit system employees, at-will employees, and some would be required to exhaust and others clearly wouldn't. It just...
Well, the argument, I guess, is that if you're a non-merit, you need additional protection. And I mean, I heard Mr. Thompson say
for
that.
non-negotiated merit rights, right? For non-negotiated merit rights that are more a function of the legislature than any of the other non-at-will employees that we're talking about. So no, I don't think the protection argument works, and I also think we have to come back to the fundamental, and this is a good time for it. The merit system employees are going to be more likely to be in the position of being whistleblowers, as we've seen in this case. They're going to be the higher level employees protecting the higher level interests, potentially. And so if anybody needs the protection of the district courts and an explicit right to attorneys' fees and costs and injunctive relief, and if I might add, punitive damages when it's available, not in this case, and emotional distress, it is those higher level merit system protected collective bargaining contract employees, including their at-will friends, under the rubric of public policy claims. Thank you.
Ms. Flynn, thank you as well, and Mr. Thompson, thank you again. The case of Welch versus Wahlert is now then submitted, and we'll next hear the arguments in State versus Mulatello.